Well, all right. So let's pop it up right here so you guys see what I'm talking about. So this is what I am talking about. This is the motion we're going to be getting into and going into in depth today, which is filed August 15th at 2:55 p.m. So I guess it's the 16th over there for you guys. It's the 17th here in Asia. I live in the future. But this is a filing in the state case of the Central Florida Tourism Oversight District versus Disney Parks and Resorts, Inc. Case number 2023 CA 0118180. And yes, once again, guys, we are live. We are live. Do not need to ask it a million times. We're live. All right. So this is a Orange County, Florida civil case. And this is a summary judgment motion. So let me explain to you guys what summary judgment is and why it's so important. So summary judgment can effectively end a case. Summary judgment is saying, hey, before this goes to proper trial, before we go in and do the whole witness thing, you guys all know what a trial is. You watch Depp versus Heard, or you've seen, OJ or some other main trial. Before we have witnesses and testimony and documents and evidence and closings and openings and counters and all this other sort of things that go on as part of trial, a lot of cases are handled on summary judgment, which is pre-trial. And that is making a motion saying, hey, before we go to trial, there is enough information, we have enough facts that we can decide this based on the law. So we can rule right away based on the legal matters and say, as a matter of law, this case is closed. We can issue a judgment and we can close the case. So you end the case early. Now, this is a good thing for a lot of people because a lot of people don't want to pay for going to trial. Now, both the district and Disney have a lot of money. Disney may have actually less money than the district because the district can just tax or issue a special assessment to get more money if they need it. Disney doesn't have that same pleasure. Now, the district filed this case in state court. So the federal case was filed by Disney. This was filed by the district. So the district really has an incentive for summary judgment here. If they can get a win without going to trial, they save money and they get what they wanted faster and right away. So this would be a massive W for them. Now, the standard for summary judgment, and this is it's a shorthand, right? Doing a very shorthand here. But you have to presume, you have to look at the material facts that are not in dispute, right? So if there's a material fact that's in dispute, you have to construe it, you have to interpret it in the favor of the non-moving party, which means the party that's not filing the summary judgment motion. So remember, this is a motion that can end the trial. This is just the same as a jury verdict or a case verdict. It's just the same as a verdict. In order to have that awesome power of a verdict, you need to have some presumptions if you're not going to go to trial, if you're not going to fight this out between two parties. One of those is you take everything in the light most favorable to the non-moving party. So in this case, plaintiff, you can see, is the one who's motioning. And because plaintiff is motioning and plaintiff is the district, everything has to be construed in the light most favorable to Disney. So as we go through this today, guys, as I go in depth, I'm going to be talking to you about the law, but I will actually, and I know this is just going to be, you guys hate it, but I'm going to do a devil's advocate in the light most favorable to Disney. I'm going to try to make those arguments and give you, okay, when the judge is looking at this, what is the light most favorable to Disney? What's the best scenario? So we can get an accurate assessment of whether Disney is going to win this or not. Because if you don't do that, you don't do it right with summary judgment. So let's jump right into this motion, guys. And 429 of you in the chat right now. So awesome. Make sure you guys are smashing the like button on the way in. And also, let me just put this out here too. A lot of folks over here on my locals, appreciate all those on my locals. C3 Metal, TMF Squid over there in the pig slaughterhouse. Mike likes tacos. Danielle's over there. Jay's over there. So shout out to all my locals, DGens as well. All right. So let's get right back into this. All right, so let's go into this, and I'm gonna read most of it, but I may skim some of it. So this is the plaintiff's motion for summary judgment on counts 1, 2, 3, 4, and 6. So there's 5 counts they're moving for summary judgment on. Now, let me be very clear here, guys. There are 9 total counts here in this case. 9, okay? 9, 9, 9, 9, 9, like Hitler from Downfall. Very easy to remember. But each of these counts alone by itself is enough for Disney to lose and the district to win. This is why I am so bullish on Disney losing. And I know a lot of people think, Andrew, your titles are clickbait. They're totally clickbait. No, I'm pretty damn bullish against Disney here for the district because they only have to prevail on one. Any one of those 9 counts and Disney loses because it invalidates their contracts. And once those contracts are invalidated, it's over. It's done. GG. So they just have to win on one. Are there 9 or 9? Have it your way, Andrew. Have it your way. So let's jump right into it. For each of these counts, there's no genuine dispute as to any material fact, and the district is entitled to judgment as a matter of law. This is the summary judgment standard, guys. So when I told you about that, dispute of material fact, that's the standard. So the standard is there is no dispute as to a material fact. So when we go through these counts, I'm going to say, well, how can Disney dispute that? How can they argue that? What evidence have they presented to counter that? Let's get into the background. Prior to February 27, 2023, the district was known as Reedy Creek Improvement District, RCID. Mere days before the Florida legislature reformed RCID in its governance and changed its name to the CFTOD, the Central Florida Tourism Oversight District, RCID and the defendant, Walt Disney World Parks, entered into 2 last-minute, that's me editorializing, agreements that are the crux of this case. A 30-year Walt Disney Chapter 163 development agreement and the Declaration of Restrictive Covenants, collectively called the agreements. And yes, by the way, I did start 30 minutes early because I want to be able to get more in here and do more. So for those that may have gotten a notification that was a little bit early, it happens. It happens. But yeah, glad to see everybody here. 525 of you in the chat. So awesome. So these agreements were the product of backroom dealings in the face of imminent and sweeping legislative reform. Dude, blown out of the water because this is exactly what it is. And we're going to see here how this was rushed. These agreements were rushed. These agreements were, as they say here, 11th hour, which were attempted to use to control the board into the future. So they lost control. The state took control from them, and they wanted to try to maintain that control. Shortly after its appointment, the district's new board uncovered these agreements and a host of procedural and substantive flaws that plagued them. So, guys, procedure means obviously there's steps you have to follow. In Florida law, there are statutes. And statutes require very strict adherence. They're kind of like nuns. You got to do everything right or you're going to get the ruler. But with statutes, if you do not follow the exact language of that statute, it doesn't work. It's illegal. It's impermissible. And we're going to find out that in many cases is what Disney did because they were rushing. They didn't follow the statute. They didn't strictly conform to the statute. That's the problem with this, such as with proper notice. And we're going to get there. We just want to explain that. And substantive is like the actual law, like the beef. And the type of substantive law we're going to talk about, so procedural would be things like notice. Substantive is things like I told you about ultra vires. I explained this to you guys, and we're going to talk about it later on when they talk about it here. But ultra vires means beyond the powers. And I told you guys from the beginning, I've said it for a year now, that it is beyond the power of a government to delegate their governmental powers to a private industry like Disney. That is beyond the power of a government. That doesn't exist. You cannot do that. It's against Florida's substantive law. We're going to see that backed up here. So continuing here, after a public hearing during which the district heard presentation from counsel regarding the illegality of these agreements, the district adopted legislative findings detailing legal defects in the agreements and concluding the agreements were void ab initio. Disney, however, continues to insist the agreements are valid and enforceable. Yes, they do. Even in their federal case, they continue to contend this, creating doubt about the district's ability to govern. In fact, they're already fighting the district. Consequently, the district filed this lawsuit seeking a declaratory judgment, saying the agreements are void and enjoining Disney from enforcing them. So that would say that those agreements, which transferred this ungodly power to Disney, are now void. And now the government has its government powers confirmed. Disney did not take those away, and Disney has to play by the rules like everybody else. So here's the 5 counts that they are going into with summary judgment. Now remember, there's 9, but as they say here, each of which independently entitles the district to the relief sought. So the district can get a declaratory judgment if they just prove one of these. So let's read through here. Number 1, count 1, failure to provide notice to the public hearing. So this is the notice thing. I've been talking about this ad nauseum. Notice. They fucked up on notice. Sorry, guys, to curse here, but they really messed up on notice because they didn't give every landowner notice. They just gave Disney and themselves notice, not every landowner. So that's count 1. Once again, by itself, that's enough to invalidate this. Number 2, Ultra Vires Act in violation of 163. That means it's beyond the powers of 163. They went beyond the law. That's what happened here. Count 3 says the district lacked the authority and jurisdiction to enter into the development agreement. And 4, violation of Article 7, Section 12 of the Florida Constitution. We're going to get into this one. This is actually the delegation of powers to a private industry. This one right here, Article 4, it violates the freaking Florida Constitution to delegate government powers to Disney. Yeah, it's a big deal. This one, I think, is really, really strong, and we're going to get to that when we scroll down to count 4. And then last, the unlawful delegation of government authority to a private entity, which is just in general and substantive law. That's wrong. So violates the Constitution, violates substantive law. You cannot delegate power of a government to an HOA. Yeah, Iger cannot be declared king, Ted. But let me get this super chat. Thank you, Rain Nation, for the $5 super chat, which says Disney couldn't do this without government approval. Both does the government and Disney need to be accountable. I offer tall trees and short ropes. Yeah, in Minecraft, of course, Rain Nation, of course. But they are being held accountable, and that's why we're doing these streams. It's why I talk about this stuff, to hold them accountable. Not everybody's doing that, guys. And frankly, most people are still out there simping for Disney, even though they are absolutely full of lies, and even though they're going to lose here. They need to be held accountable, not just in the courts, but in the court of public opinion as well. And you guys can help by that, by sharing this information out there and educating. This video has been a clip of a previous live stream, and it's clipped so you can get the information in a shorter, compact package, the information you need. If you want the full video, the whole context, the whole thing, you can check out the full stream that is in the link below. Check that out, and I will catch you guys later. Peace.